Robi Kumar De to formally introduce to our today's speaker, Dr. Saptarshi Ghosh sir. Robida, now this is up to you. Yeah.
A very good evening to you all. It is really my pleasure to introduce Dr. Saptarshi Ghosh, Professor, Department of Library and Information Science, North Bengal University. Dr. Saptarshi Ghosh did his MA, MLSC from Jadavpur University with first division and position in order of merit. He did his PhD from Jadavpur University. Dr. Ghosh joined his services as a faculty member in the North Bengal University in the year 2001. Dr. Ghosh has published scores of articles in Journal of International Report. He has held a number of administrative positions in his professional domain. His area of specialization is application of information and communication technology in LIS. He is also interested in multimedia development, web application, object Pascal, etc. He is an avid researcher of sociology of information science and its diffusion in knowledge economy. Now I request Dr. Saptarshi Ghosh sir to deliver his valuable lecture on the topic intellectual property right. Sir, please, sir.
Yes. Am I audible, Ravi? Ravi?
Yes,
Yes,
sir.
sir. Yes, sir.
Okay then. So, good evening to all of you. First of all, I want to tender my sincere thanks to the principal, honorable principals, Reverend Principal Swami Kamalasanandu um, for short introduction of myself, for introducing me in brief. And at the same time, I must say that it was a kind of bolt from the blue that suddenly I got a call from Robi and obviously the mm, supervisor of Robi that I have to deliver some lecture on IPR. And I was rather surprised that on the holy day of Mahalaya, when we were rather in a festive mood, and in that particular time, why these people are rather arranging such a kind of thing. Let I got that one. That is, most probably they are trying to mix up something. That is a kind of starting the holy thing in the very holy day. So where the reciprocity amongst the people regarding the creativity of the mind, or rather the intuit of the mind, that are rather coming out, that are being manifested, that can better be acknowledged to the world with the help of some bit of logical premises, and logical as well as you can say that is the some lawful practices. So with this one, I think I rationalize that one. It's okay. It's good, and so that those who are present over here, that is, I'm rather saying that one total number of present participants are 101 right now. It is showing, but at the same time, I am also saying that one this particular deliberation is um, rather being transmitted directly or telecasted directly to stream to YouTube live. So other fellows are also there, most probably. They are also listening to this. Now, the first thing is that intellectual property right, this particular issue is a kind of zone where there is, it's not only the purview of a section of people like that of we, the library people or the information professionals. So specifically the IPR here, whenever we are talking about IPR, so IPR is having so many ingredients, so many catalysts, so many factors involved over there. So it is rather linked slant to more to law. And at the same time, you will see that one here in IPR, the interpretation plays a big role and the law of the land plays a big role, because IPR is and anything regarding law where the implementation is there, and so judiciary plays a big role. So what we need to know, and in this particular presentation, what I shall try my best to highlight that one, that is for the academic perspective, how far this IPR is applicable, and at the same time, we, the information professionals, those who are here to cater as a facilitator of the knowledge, how we can give you the better knowledge whenever you are in trouble and whenever you are seeking such information. So that is, suppose you are doing something and at the same time you are rather in a jerk and you can't do the proper justice with that one because of your ignorance with that law. So in that case, so we being the renderer, we being the facilitator, how we can do this one much more better. That is the perspective of this seminar. So this is what right now, let me, I have one PowerPoint presentation. I do not have that problem of talking, but in online education, because this online education, distraction is rather one of the biggest problem. As because in online, any kind of online derivation, as because the person who is delivering the lecture, or rather addressing one group of people, and this one to many communication is always hindered because of the human touch. And that is where I can't see your eyes, whether your eyes are rather having the sparks, whether you are ready to accept that one what is rather coming, and at the same time the accords, discords, your agreement, your disagreement with the notion that I'm rather trying to foster with you, I'm rather trying to disseminate with you. So obviously some problems are there, and that is where these online education, or rather the online deliberation, is having these flaws. So one thing is that in online mode, so practically speaking, the important one is that is we have to keep our deliberation short, so that, and at the same time, we must give some bit of time to process that information that we are rather catering. So that's why in this deliberation, I will take the liberty of doing something like giving you some PowerPoint slides, and at the same time I will say you something, and at the same time I will take a pause so that you can have that one with you, you can grab that one with you, and then at last we will reciprocate, and I will try to relate some of the recent incidents with that one also. So, but to be honest, I must say that one, see, I am not rather one innovator, or rather a person who is giving something very new to IPR. So rather you can say that one. So this is a kind of cumulative, or rather this is a collective process. So information, scattered information, jotted together, scattered information, clapped together, and that particular information is being disseminated to you with some bit of value addition from my end. And obviously, all of you, all of you were the scholars, teachers, as well as one individual having the understanding of society, you know very well that law is having its own dialect, law is having its own language, law is having its own grammar, but at the same time, the perception of anything where you can say that one the good or evil, that you can justify that one much more better, just like any other fellows. And that's why I have a strong faith with you, that is this one. After listening to this one, you will also be one information searcher, you will also be one information seeker, and you will try to identify those information so which are relevant to you, and at the same time you can sharpen yourself for the very discipline, or the very the micro discipline you belong to. So with this one, with this prelude, so let me share what I have in my armor. So just keep a good tempo with you. Okay.
Thank you, sir. Thank you.
So say, okay, let me start this one, the slideshow. Okay, browse by individual manually. Okay. So we are starting with this one, that is a peep into intellectual property rights, that is IPR. This is intellectual property rights, not intellectual property rights. A peep into intellectual property rights on academic research, the role of information professional. As you know, this is rather, you can say, the duty, or rather, this is one task ushered to us, those who belong to a particular discipline. That is, whenever we are saying something, at least where we are or how we can deal with that one, we need to show that one to the greater community, greater academic community. And that's why the last portion, that is the portion that is coming after colon, is coming. But ultimately, so the whole thing is really required for each and every one. And this subject is so wide in its periphery. So at least in one lecture, or even many times, you won't even have that proper understanding also with a particular lecture. So you have to, most of the times, almost all the times, you have to read those things and then try to reinterpret that thing. And in case of travel, you may talk with your friends, those who are dealing with this one. There is some kind of those who are having the background of law. So many a times, that is the demystifying of many of the things written over here requires some bit of clarification from the legal standpoint. So with this one, we're starting that one. And the very first slide, uh, I have no problem of saying that one. I took that one from the college homepage itself, and the college homepage itself, because I saw this one. I noticed this saying after I prepared my slide, and ultimately I found that one. What is written here and what is stated by that Mahamanabu, that individual, that the greatest individual or greatest person in the world regarding theology. Sri Ramakrishna is stated that one. Many good sayings are to be found in holy books, but merely reading them will not make one religions. So here I am having lots of slides. Just only going through this one will not make the sense, but the sense is that you have to extract the essence from that one with your senses. And that is what is the most important thing that I'm going to deliver. Okay, so I have written that thing. That is, I have taken that one from the college homepage for my own tuning, the self-tuning. And that is what we are starting with this one, the introduction. And introduction, so we are going directly to the reality. So we are having one IPR portal. That is the IPR portal India. And if you go there, that is why you will see that one different types of IPR components are there, and the formalities that are required for that one, the patents, designs, trademarks, geographical identifications, and also the other perspectives are also given there, and the publication, recent development, specifically related to the territory of India, that is given there. This is one portal having all information clubbed together, but these are the government information, and obviously there is no interpretation in that sense. So for interpretation of something, that is how the academia is thinking about this one. For that one, you might have to search the different sites, like you see, that is the EPW, that is Economic and Political Week, Politics, Political Weekly, and also the other open source, or rather the closed source repositories, from where you will get lot of materials where the critical perspective of IPR is given. But before going to the critical perspective, let's start with that one. That is the very basics of IPR, and how and where the IPR is, and where what is the role of us, or where we are rather standing in the IPR, not era, rather IPR ambience. So this is what, this is the WIPO definition, and you know that one, that is the World Intellectual Property Organization that define this thing. And what is the intellectual property? Because the ingredients of IPR is coming in the next slides, but you know, this intellectual property, they stated that one, it covers virtually almost everything created by the individuals, and where they stated that one, these are having the literary, artistic, as well as the scientific works, performance of the performing artists, like that if you, that is something you developed of your own, phonograms, broadcast, invention in all fields of human endeavor, scientific discoveries, industrial designs, trademarks, service marks, commercial names, designations, protection against unfair competition, that is competition, and all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic field. Here is the catch. That is, whenever you are saying that one, that is resulting from intellectual activity in the industrial, scientific, literary, or artistic field, believe me, this one, this statement, the embedded perspective is that here this intellect is not rather the intellect of the very organization, intellect of the individual, the human element involved in that one, human element with that perspective, industrial, scientific, literary field, artist field. But whenever we are dealing with that one, that is the IPR Act. So if we do belong to that industry, if we do belong to that scientific field, we do belong to one scientific institution, obviously there is the reciprocity involved. And that's why the organization itself is something like one institution, like one individual, one entity, which can claim that right, having the very notion of the individuals that are there within that organization. And that's why whenever you were saying that one, you were working from a college, or you are rather working in an university, and whenever you devise something, wherever you invent something, that invention is not the only your invention. That information there is, that the reciprocity is there, that is the university as well as the inventor who invented that one. But the sublime aspect is that one. At the back end, the human intellect is involved. So that is where the intellectual, and that is what the intellectual property, because whenever we are talking about the industrial, scientific, literary, or artistic field, for industrial organization, scientific organization, you know that one, right now we are talking about the knowledge management, and we are talking about the organization, that is organizational knowledge management. And once we are talking about organization knowledge management, organization itself cannot develop knowledge. So organization knowledge is developed by the individual. Organization can only foster that one. They can make some ground for that, so that the individuals who are working in that organization, they explicit, or rather they can manifest their tacit knowledge, they can manifest their tacit to explicit. And that is where we are starting from. That is what the intellectual property is. And regarding intellectual property, right, we're seeing that one, there are the different. So it is not actually the issue of India, or rather, this is what this particular perspective is having, the global perspective. And see, from 1883, 1996, although I have written here 1996 and this one, but you can extend that one up to 2000, where you have the Information Technology Act, and then you can even extend that one to up to 2012, where we are getting the amendment of Copyright Act. So practically speaking, this one is being nurtured, this one is being talked, this one is being evolved for a long time, near about 150 years. And during all the time, see, this is where, but at the same time, see, the terminology is rather changing. and this one, that the terminologies are changing. That is first of industry, industrial property. And whenever you are seeing this one, this industrial property, trade related activities, you can immediately identify the phases of the society, how the society developed from the agrarian society to industrial society, from industrial society to information society, from, or that is that, you can say that one, that is techno technocratic society. And then we are saying that one right now, we are living in the knowledge society. So practically speaking, these jargons, these buzzwords are each and every time, these are the evolution of the time. And this can, you can say that one, the most of the cases, this reflects the social reforms also. So that is what you will see. But most of the times we try to protect the rights of those who are the creators of new knowledge. We try to do that one. Why? Because we try to protect the knowledge of those creators, because they should get motivation. Otherwise, the new innovators, they might not be very much interested if we cannot protect that one. And that's why such treaties and such type of things came. And you see the basic principles that are governing this IPR are having that one. So we have that one, that is the contract between the creator and the sovereign state. The contract between the creator, so what I am saying that one, the inventor, where I am saying the author, where the person who already exposed, who already manifested the cognitive and intuitive capability he is having, and that is to recognize or to give him the recognition, and the contract between the sovereign state and the creator, that is one first thing. The protection for revelation and the balance between, now here is also one important thing, that is what you see, this is first one is not going towards monopoly. The second one is actually countering that one. See the balance between rights of creator and public interest. Here comes the society. See the first one where the individual and the state is involved. And if you consider that one, the state itself is rather for the people, by the people. So first one, the state is rather making the contract. And in the second one, here the balance is rather given, or rather the balance is being made. That is up to what extent these rights will be given to the creator, and up to what extent the public interest will be uh, mitigated. And that is where the rights and limitations, that's why you'll see that one in the later slides, and not many of you know that one. So each and every right is having its end also, end. So whenever you are giving them that one, that is the right, that is you can enjoy that thing, you can keep, you can retain your ownership, but you have to abide by that one, that is you cannot exceed that one beyond that particular period, because of the public interest. And many of the things are rather given there, which can't even get or which can't even be included under this one, that is the intellectual property right. Okay, so now the nature is what? So the nature of intellectual property, whenever we are talking about the different facets of intellectual property, then we are getting that one. First one, there's the creation of human mind. That is you, one author, you created something. Second one, that is the intangible property, that is the intangible. So where which you can have that is which is having the physical presence, and exclusive rights given by the statutes, that is you will be enjoying your right with the help of the statutes, and attended with limitations and expectations, where the limitations are provided And at the same time, the exceptions are also there. Not all the times you will enjoy the same thing. It is time bound and it is territorial. Last one is very important. Why? Last one is important because intellectual property, anything comes under the name or rather with the vocabulary at the end as act is bound to be territorial unless it is the international or like that. So we have in law, we see we have the international law. At the same time, law is rather the only subject which you can say that and which you can confine to a territory. You cannot confine physics in a territory. You cannot confine chemistry in a territory. But law, way that is a broader perspective, something different. But whenever you are going for the implementation of that one, you must have to keep in your mind it is having its territorial boundary. That is up to that only we can implement or we can use this one. Okay. So next thing is that, so now what are the intellectual properties and in what are the ingredients of IPR and what are the connotations of IPR? What are there in IPR? So in IPR, you see, if you divide that one, the largest share is rather the copyright and related right, one aspect. And the second one is the other rights where the industrial perspective. So copyright and related rights, this is much more linked with the academics and the industry, this is the production. And industrial property rights or industrial one, there is the patents, industrial designs, trademarks, geographical indications, and layout designs, topographies, trade secrets, protection of new plant varieties. So these are rather kept under the industrial property. So now in this particular lecture, as because I already told you that one online lecture should not be made lengthier. So that is why we'll be, so see the color code here. So copyright will be, I will cover copyright, and regarding industrial property right, we'll cover patent, industrial design, geographical indications, and protection of new plant varieties. Others I'm not saying today. Okay. So now we have this one, that is the laws, that is intellectual property laws. And you see the Copyright Act of 1956 or rather 57. So the first enactment. And you see this was amended in 2012. This is for the higher education. And you see only one act which is related for the higher education. Others are rather for the applied perspective. That is where you already made something. Although the blood zone is there, you can't say that one that is industry is rather you have no perspective with higher education. It's obviously there. But so if you distinct the if you make the categorization, you see that one most of the acts are rather having the industrial policy like that and information technology. Information technology that I already told you, that is whenever the ICT boom came, and obviously we got that one, a new kind of challenges, a new kind of challenge that has been ushered to us, or rather we started facing that one. And that is where the problem with the information, and that's sort of why each and every country in the world had to prepare their own Information Technology Act, and India also devised their own Information Technology Act. And Agriculture and Cooperation, the Protection of Plant Varieties and Farmers' Right Act. I have something to say about this one, but that will be done in later course of time. So this is where we are getting that one. See, the Patent Act in 1970, the Designs Act in 2000, Trademark Act in 1999, and Geographical Indications of Goods Act in 19, this is also in 99, Semiconductor Related Circuit Design Layout Act, this is in 2000, and Protection of Plant Varieties and Farmers' Right in 2001. So, and then in 2020, the Farmers' Bill. Okay, I haven't included that one here, but I will tell that one in the last slides. So this is what we are having in our Indian perspective. We are having this one, that is These are the bunch of acts we are having. And with that, we can proceed with the copyright and the related laws. Now, see, regarding copyright, the scope of the copyright, whenever we are talking about this one, that is the original literary works, dramatic works, the dramas, works, ideas expressed in the material form, musical and artistic works. These are rather coming under the first group of copyright. Second, we have the cinematograph, that is what we call motion picture. And the third one is the sound recording. And here you see this one, the copyright. Just let me give you one example of this one. That is, Ananda Publisher is one of the biggest publisher in India, which is producing or which is rather publishing the Bengali books as well as some of the English books also and other language books also. Now, many of the authors, very, very, very illustrious authors, they publish their literature from Ananda Publishers. And see the problem, if you go to any kind of website in Bangladesh, any website, Bangladesh website, where the book websites of Bangladesh, you will see that one, the most of the cases, the authors of West Bengal, books written by the authors of the West Bengal, as well as books written by the authors of Bangladesh, are available freely, or you can download that one freely. But believe me, the form through which you are downloading that one, the PDF form or the EPUB form, or rather you can say the text form, whatever be the form. So until and unless you got the certification from the publisher, you can't publish that one. But you cannot exercise, you cannot implement your copyright law here, as because this is rather one another country, one sovereign country, which is not in Indian territory. You cannot do anything. So you see, your market is rather encroaching. Your market gets encroached. You can't even sell your materials in Bangladesh. You can't sell even that one to other parts of the globe where your readers are there. So like that, many of the sites are there. So from where you can get that thing. So this is where the original literary, dramatic, musical, and artistic works, that is the artworks, the musical works. I think those who are a bit older have heard the very name of one particular company like Napster, who first started sharing the music. So that is the MP3, or rather the music files, to their peer groups. And P2P network was once upon a time very familiar, right now also available. The e-mule, those who are having the very software e-mule or e-donkey, the P2P software, or rather BitTorrents. Right now, torrents are also coming. So torrents are also playing a big role. At least once upon a time they did, but right now the government has taken some bit of measures against those things. So you will see that. So Napster first started that one, that is disseminating, or rather providing, giving their peers the music files. Obviously, first free of cost, and then by charging very meager amount, and the original creator of the music, whether he is one, that is, you can say the musician, or rather he is actually the arranger, music conductor, or rather he is rather the developer or composer of a particular new music, or rather you can say the new sound recording. So he was rather debarred of getting their profit, and that is where is the problem. Cinematograph, once upon a time, lots of the places were there in India from where you can download the whole movie. But right now, you can download, but you will have some bit of hard time over there. So in copyright, we are having three different perspectives, like original, literary, dramatic, musical, artistic work. then the cinematographs and films, then sound recordings. And then here comes some perspective of moral rights, like that of the right of authorship and right of integrity and the inalienable rights. Inalienable rights, and here you see the right of authorship. That is, you are the writer, and you obviously get that one. So, I think one particular aspect we can say that one here. See, we can link that one, but today I'm not going to tell that one because on the 9th another lecture is there, and here there one of my friend will tell something about that one. But this right of authorship, right now this is being challenged each and every time, and that's why in even the academic parlance we had to invite the ICT fellows to divide something to check that one whether the right to authorship is really been restored or not. And we started using the anti-plagiarism software tools. And the right to integrity, that is the digital manipulation. So you are rather writing something, you are rather changing the name of the author. And when no right to display, we are rather displaying that one. I will show that one in this at the end of this slide. And inalienable rights, that is where the moral rights, this is what the Bangladesh is doing, inalienable rights. That is, so they are rather, so according to Copyright Act, so they are rather the alien to our perspective. And here is the problem, that is we can't do anything, but they are doing that one in front of you, but you cannot challenge that thing. So, and you see the economic rights are there in this perspective, where the right of reproduction, that is making copies, that is edition of a novel, storage in the computer memory. But here is also the problem is that the right to reproduction, once you are having a software, you can make several copies of that to use that one for your own purpose only, but you cannot use that one, you cannot give that one, you cannot disseminate that one, you cannot distribute that one to others, because this is nothing but the breaching the license. So here the economic right is there, and that's why in most of the cases the software today, whenever I was talking about this one, that is how this presentation will go, or rather how this presentation will be made. And then I got that one. So Robbie told me that one. So they are using Cisco AVX, and that is the procured version, purchase version. The college purchased that one because they wanted to go with such kind of thing, that is the online education, and they properly thought that one we need one licensed version of that one. So now you are entitled to use that one for your institution only. And whenever they purchase this one, and whenever we purchase Windows, whenever we purchase any software, one license is always given there, obviously in digital form, in binary form, but you can read that one. This is the natural language, this is written in natural language. And irony is, individual never ever read that license very clearly, because where it is clearly written, you are just given, you are the license, you are not the owner. You are just given the license to use that one for your own purpose only. You cannot distribute, disseminate, re-engineer this thing and sell that one to other. Even distribution to your friend is rather, you are rather breaching the law. And that is what the first thing, that is what the right of reproduction, that is whether you can reproduce that one to the other machines or not, or making copies. Right of distribution, issuing copies, the digital distribution, whether it is really worthy or not, you can do this one or not. For the open access material, this is the most important thing. Here, the right to distribution is always allowed, and issuing copies. And that's why open access is always called as the copy left. But right now, it is not copy left in that sense. Some of the licenses are obviously there, the Creative Commons and other common share alike licenses are there. And right to communication to the public. There's a public performance, internet communication. This is also the restriction given, that is actually in the coming under the purview of Copyright Act. Whether you can, so almost all the times you'll see this Durga Puja is coming, and almost all the pandals, whenever you will hop the pandals, you will see that one. So everywhere, they're actually playing the musics. Some of the cases, the Rabindranath Tagore songs, some of the cases you will see that one. The Mahalaya itself by Birendra Krishna Bhadra, some of the cases you will see that one. They are playing the Shehnai of Bismillah Khan. But this right to communication to the public, this whether you can play that one in the public place or not, no one is reading that one. That is very important. It is written in the cassette itself. It is written on the media itself or the cover itself. Whether you can play that one in the public for public performance or not. And you see the internet communication at the same time, whether you can communicate that one in the internet. So next is rather so economics rights two, where the adaptation right. So adaptation is conversion into another form. That is literary to drama or language, literature or poetry or novel. And you are going to make that one as drama. If you see that one, that is what Joy Goswami used to say, Jara Brishtite Vijay Chilo, you know that one. That is what was transferred to, was converted to one drama by Usha Ganguly. Okay, so that is what that thing is rather the adaptation, and you have there is the copyright also whenever you are trying to change the mode of that one. And right now a lot of short stories are rather being made to films and in motion picture. Whenever you are trying to get that one, and very recently that one thing came up, that is the two groups are rather claiming that one they purchased the whole rights of Uttam Kumar, and they're saying that one the family of the Uttam Kumar cheated them because they are not getting all the things. So this is where they are trying to get the resources from that particular house, and they are trying to do something special with that one. They try to modify that one. They try to convert that one into other form, obviously with its own aesthetic values. But to do this one also, you have to take the permission. As for example, right now, if you want to make one film with the from the story of Professor Dr. Satyajit Ray from Ray, so you have to take that permission. So this is the adaptation rights, picturizations, comic formats, right to make a cinematograph film or sound recording, translation rights, rental rights, and resale rights for original artistic works. Reselling that rights are also important for the economic perspectives. Now
Sir,
see,
uh,
yes.
sorry to interrupt. Can we ask some question in between, or we should ask at the end?
Okay, you can go for that one. So I have no such problems. Okay. If you want to go for the questions in between, so then it's okay.
Okay. So, no, I was thinking one doubt was there. So, should I ask now?
Okay.
Uh, Actually, that thing you said, that that publication, that Bangladesh is publishing some that books from India, and we can't do anything, right? Uh, but sir, we have seen, but a lot of our in India also, lot of colleges or institute share books, like colleges share e-copy or scanned copy of books, which are not copyrighted, right? They have bought the hard copy, but the scanning and sharing. Is it okay, or is it illegal, or what are the things out there regarding that?
So very, very pertinent questions. Okay. Okay. Very good. So, okay, let's make this one interactive. So according to the Copyright Act, what we are having that one, so you cannot copy the full book or the total book. You at least you cannot copy that is more than 75 pages of the book. Obviously, 75 pages of the book, and you cannot copy the book from cover to cover. That is not given, that is not even allowed for the in India also. And see, regarding Copyright Act, what you asked me, that is rather very a kind of question that is I have to answer that one by going by extending something from this. See, according to the Copyright Act law, each and every publisher who are publishing their books, they must submit their books to the national libraries. So the three libraries or four libraries, okay? So the National Library, Connemara Public Library, and then the wings of Madraj Library and mostly Khuda Box Library. So they have to submit the copies of that one. But do you know that one? Most of the publishers, they do not even send the copies to the National Library or rather any of the libraries, which they must have to provide. But there is no such check and balance. That is whether the publishers are rather really giving that one to them or not. So this is rather, you can say, one challenging thing. That is, now you can say that one, who will tie the bell or who will actually not it. So problem is laws are there, but at the same time, breaching of laws are there. And you see, so breaching of laws are there. So this is one thing. Another problem is that so once you are rather, and the last thing is that whenever you are talking about this one, I will come to the very perspective of fair policy or fair use, one very term that is very much relevant, and many of the individuals know that one, that is the meaning of fair use. And this fair use is something which is defined. And at the end of this presentation, I will show you one document published by National Digital Library of India, although I cannot uh, cite that one here because they have stated that one, that right is not available right now. And that is what the Copyright Act for the librarians. And it was published in the year 2020. And once this was being formulated, I was there in their different committees. And right now, one write-up, one prescription came for the library people just to understand how to deal with the copyright laws. And the clear instructions and explanations are given there. And one individual, Professor Prabuddha Ganguly, who is the practicing lawyer, pleader in the Delhi High Court, is and another retired lawyer. And obviously, in their group, there were 5 or 6 fellows, and they asked several inputs from different individuals, law firms everywhere, and they made 132 pages prescriptive law for this one, that is maintaining, retaining the copyright law in the libraries of India. And that's why the librarians require to store that one so that they can disseminate that copy to their users whenever the users are coming with such type of thing. And there, the perspective of copyright and what are the flaws and how it can be mitigated, the challenges we are having, the fair use, everything is given there. Okay. So with this one, I am rather extending this one. So we have this thing that is the ownership right. So ownership is retained with the literature with the author, drama with the dramatist, music with the composer, artistic work with the artist, and you know that one, that is sound recordings with the producers. So this is what the ownership. And so authors, when the authors are owners of rights and the exceptions of, so in the course of employment employer, here the ownership is having the problem, that is employer employment. That is what, whenever you are saying that, see, employment by newspaper, magazine, employees has the publishing right, other rights with the author. So in the Puja novel, Puja Shankha, or rather in the Puja publication, someone is writing one novel or rather suppose Samaresh Majumdar is writing one novel. So obviously the publishing right rests with that particular publication or publishing company, but the other rights means there is the moral rights, the authorship rights, it is rather rests with the author. The author cannot forward or cannot submit this one to any other places without the permission of the publisher. This is same thing that you know that one in case of our open access policy and in case of the policies by the publishers where you see that one, that is once your article is published in the journal where you have that one, that is the journals which are rather you can say the closed access journals, and if you want to publish that one in the open access journal, some bit of embargoes and other things are there, either 6 months or 12 months, like that. Preprint you can submit, not the whole one. So such type of embargoes are given. So this is where, although you are the author, but you are not being considered as owner. So you are having the right of, so a kind of notional right, but you do not have. So photographs, painting, cinema, for valuable consideration, person who pays money. So here the ownership is rather governed with that one. That is who pays the money, not the author, that is the actor. So who pays the money? Obviously the producer. So now I'm giving that one, that is exceptions. I am right now delivering the lecture in the public, the person delivering. So author is the owner's exception. That the person delivering. Government work, the government. Public work, the public undertaking. And work of the international organization, that international organization. That. And then you see another perspective regarding this one is the work to apprentice to teacher. That is work of apprentice to teacher. This is where the exceptions. The teacher writes a book, then then the teacher, because he is employed to teach and not to write. See the exceptions, see the logic here. Question papers, paper setters, you are not the authors, although you said the question. Okay, encyclopedia, dictionary, or editor for collection, and music under contract by the film producer, that is the film producer, or rather those who is rather giving the money. So next one is how we can secure this one, the copyright. So we can formality free protection, that is formality free, no formality, but we are rather protecting that one under the Copyright Act. Voluntary registration. So in our Copyright Act, we have that one, that is the section 44 and 45. And registration does not as a matter of law establish that what is registered is in fact and in law copyrightable subject matter. So registration does not as a matter of law establish that what is registered is in fact, what is registered in fact, and in law copyrightable subject matter. So this is what, this is also copyrightable, and this can be challenged also. So registration does not matter. The law is already established for that one if some controversy creeps in. So next one is the duration of the copyright. You know that one. That is what? The 60 years for the literary, dramatic, musical, and artistic works, and for all other works, 60 works from the date of publication. And here you see the catch is the life of the individual plus 60 years, and all other works, that is 60 works from the date of publication. What are these? Posthumous anonymous works, works of government organization, cinema and sound recording, the photographs, just 60 years. But here, that is your life. Suppose 174 years, one individual, he got the copyright in the year 30, at the age of 34. So 34 to 74, he will be enjoying plus 60 years. That is the duration of copyright. And say copyrighted material and works of authorship, where the exceptions are like that. General rule, the work for hire. So these are not copyrightable. Textbooks are not copyrightable. But once something is creating the ambiguity with the advent of new technology tool, So copyrighted material and works of authorship. See, the web-based software or another computer software. So ambiguity is there, like ebooks and see your main book, that is the printed book. Create some ambiguity, the audio, visual, or written works of authorship used in the course curriculum. That is not copyrighted. Once identified, we can license, use, or to new employer or choose it, let it go. Teaching modules, resources or others, training modules, these are not at all copyrightable material. So next one is in the research data. Right now, here is the important thing as we were discussing that one. Right now, the data is very important, and right now we are rather shifting towards data from information itself. So once upon a time we started with data, then we jumped to information, then we talked about knowledge, and ultimately we landed to wisdom according to our very phases of development of the ideas, or rather building the conceptions. So, but right now, what we are rather seeing that one, people are, or rather the research community, they are not very much ready with that one. They are not asking us for the anticipated data in the form of information we already prepared for them. So they are asking the raw data. And that's why you will see that one, a new science, a new compartment of computing science has already evolved, known as the data science. And obviously the data science, data research, and within that one, lot of things regarding data came, like that of, and obviously one name, you know that one, big data. And no one knows how big is big data, but it is rather the data, not that type of data you use for writing one article, the statistics or like that. But the research data is very important. Where? Because if you consider that one, that is the research you made something and you collected the data of your own. And that data is having the value, and that data belongs to you, or rather you and your institution. But once you are keeping the data in the institutional repository, whether you will be giving the right to others to reuse that data or not, here comes the concept of, that is the researcher's right, or rather the rights of the institution. And right now, many of the organizations, or many of the portals, data portals are there. For the Indian government also, you have the opendata.gov, opendata.gov. So, and you see an open data in. So you will see that one, you can upload your data, even the Excel file, CSV file, JSON file, XML file, you can upload that one. You can attribute some license over there, so that you are rather the generator of the data, and anyone who is using that data, so they must have to adhere, they must adhere to some bit of licensing policy like CC Commons 4 or the sharing alike license. So they have to say that one once they are using, whether they are writing some article, whether they are doing something, they must write that one from where the data came and who is the originator of the data. This is the licensing policy. The data is free, but at the same time, once you are rather providing the data, you can eventually ask the individual, that is, provide the homage to that particular person who invented or who collected that data, who organized that data. That is important. So most researchers hold into onto their research data like it is their baby, and specifically for the science domain. Obviously, I'm not actually saying about that. And so in case of social sciences also, those who are going to the field and going for the action research, stress study, longitudinal study, cohort studies, participant observation, non-participant observation, obstructive study. So whatever the different research methodology you are taking for your collection of the data, your data is your baby, because it is what you rather nurture and you prepare your intellectual output. So it is rather kept in the lab notebook or PC in any form. So what we can do, that is who is the owner of that data. So now the financial records, supporting documents, and all other records pertaining to the federally funded award shall retain with the institution. See, federally funded award. Federally here means, suppose in our case, this is the union. So union funded award shall retained by the institution. That data belongs to the institution. Okay. So that means we need to make sure that we have to access to the research data, probably true with all sponsored research. So sponsored research, all sponsored research, that research data is not the data of yours. That data belongs to the institution. And although you are the creator of the data, you will get the recognition. Even you can use the data, but you cannot claim the ownership of that data. That is what is the most important thing. Okay. So it is rather, you can say right now, that's why you will see whenever you are rather submitting your article to any reputed journal having a high impact factor, very good impact factor, there is one stricture that is they are asking that one, that is who is the funding agency. Tell us about the funding agency and as well as the supplementary materials. So if you have one funding agency, you have to take the permission of that one, whether that particular supplementary material, the related data, ancillary data, you can upload with your article or not. That is very important. But if you are one freelancer, you are individual, without having any financial thing, you are doing something of your own, in that case, that data belongs to you. In that case, the direct.org, you can upload that one to some places. Even in the government side also, you can register yourself and you can upload your data. You can attach some bit of copyright over there. Even you can copy left that one. So this is how you can make your identification or make your presence much more global by uploading that one. So this is the perspective of research data and the research data access. So we can keep the copy of the data and probably necessary for the financial records, one thing, and we can allow researcher to take the data, but make it available to us as and when needed. So this is what the import that I already told you. And that is what the record retention period specified. That is how many times you will keep that data, what is the amount of time, that is how much time is required for that one. And consider whether the data is needed to support pending patent application or not. So if the data is related with the patent also, in that case, you have to keep that data uh, visible so that the patent agencies can verify that thing also. So, and you say the broadcasting and organization, right now I'm not going to this one and coming to this one, that is the patents. And here you see the patent. This is what. Now we are going from the, you can say, the abstract perspective to rather implementable perspective, or rather having a perspective which is having its manifestation. A patent is rather the exclusive right for an invention, which is a product or process. So two aspects, product patent or process patent, that provides a new way for doing this one. The limited monopoly right, so that is what granted by the state, enables an inventor to prohibit another person from manufacturing, using, or selling the patented product, from using the patented processes without permission. And period of the patent is rather the 20 years. And you say, what can be patented? So you can patent inventions of all fields of technology, whether the products or the processes. Products or processes, like you develop the end product is rather being patented, or rather the process through which you can go for, if they meet the criteria of novelty. As for example, you see right now, you can see that one in India, we have the process patent, and some of the cases the product patent, at the same time process patent. So process patent is just like that one. So see, for the medical science, medical perspective, you will see that one, most of the cases, you will see the doctors are prescribing antibiotics. Once you are rather preparing antibiotics, so if you are using amoxicillin or cloxacillin, the combination of both amoxicillin and cloxacillin. So problem is, if you take the patent of amoxicillin itself as well as the cloxacillin itself. So obviously the organization or the individual who is patenting amoxicillin or cloxacillin, no other individual during the tenure of that patent can develop that amoxicillin cloxacillin product anymore. So here comes the very perspective of the process patent, where whenever you are making the end product, whether that is a moxidil or whether that is ampilox, that doesn't depend, that is a brand, but the process by which you are making that one, you can patent that one. In that case, everyone can make the product that is a combination of ampicillin and cloxacillin, but the real ingredients, the product is not getting product. So this is the most important perspective for the process patent. And non-obviousness, that is the inventive steps, that is where the non-obviousness, inventive steps, that is which step you invented, and industrial application, the utility also you can patent. And patent granting, the patents are granted always by the national patent offices. In India, we are also having that one. And after publication and substantial examination of the application. And we are having the existing of pre-grant and post-grant oppositions by other. Pre-grant, that is a grant of patent, pre-grant of patent and post-grant patent opposition by others. That is, suppose something is given to you, someone challenged. So, and then also it was rather been challenged like that. And then if it is mitigated, and then post-grant patent can be given. And these are valid with the territorial limits in the country, but foreigners also can apply for the patents. Okay, now some of the inventions which are not patentable, I'm rather going. So these slides are rather, you can say, speedy slides. I will go that one, so slash. So it will just go with a slash. So the invention which is frivolous and which claims everything obviously contrary to the well-established natural laws. Suppose you are rather saying that one, that is, I made one machine which can give more than 100% of performance. This type of materials are non-patentable. Second thing is non-patentable, a machine whose primary or intended use or commercial exploitation of which could be contrary to public order or morality. Okay, or which causes serious prejudice to human element plant life, like say the gambling machine. So device for housebreaking, biological welfare, terminated gene technology, embryonic stem cells. So this type of inventions are not patentable. Mere discovery of a scientific principle is not patentable. As for example, see, you can say that one many times, although okay, let it be. So, but the example is like that. Many of the times we are seeing that when people are rather writing articles with lots of uh, pictures of the software they use and the processes they made or the processes they encountered with the help of the software and the results they got with the help of the software. The steps of the processes, 1, 2, 3, 4, 5, 6, like that one. See, the problem is this one is not considered as something like research or invention. I'm saying that one. It's not new something. Using mere some tools for making some output is not rather considered as the creative genius of you. So that is what you have to say. That is, you use that tool, you discovered that one, but right now you say what was the environment, what control environment you did that one, and why the result is like that. And that is where you can prove yourself. And that is just like that. You can say, mere discovery of a scientific principle is not considered, rather, the patent and formulation of an abstract theory. This is also not patentable. As for example, right now I can say that one, TAM, that is the technology access model, TAM. And then you see TAM 1, TAM 2, UTAT, that is unified access theory of that one, that is the access of technology, like theory of diffusion of innovation. So these are there, but these are obviously not patentable. So next one, we are going for that. And so we have all such things, but right now I'm just mm, jumping to this one. So now where I'm coming to this one, the industrial designs. Regarding industrial designs, just to understand the meaning of design, design means only the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional or in both form by any industrial process or means, whether manual, mechanical, or chemical and separate combined. So these are solely judged by the eye. So industrial design, these are rather the designs, logos, you can say that one. So rights of the registered proprietor, they can register the design and they have the exclusive right. You know that one, Hawkins, the pressure cooker, that one, Coca-Cola, that one, the logo. And that is what the exclusive right to apply the design to any article. And period of protection is 10 years, extendable by 5 years. You can extend that one more 5 years. Okay. So what are excluded? Any mode or principle of construction or anything which is in substance of mere mechanical device. These cannot be considered as rather the industrial design. Any mode or principle of construction, anything which is in substance a mere mechanical device, that is just like a clock, you cannot go for that one. So it cannot be considered as rather one industrial design. Just like the trademark, property mark, artistic work, that are not obviously the industrial design. And which you cannot register. You cannot register if it is not new or original. Has already been disclosed to the public, and it is not significantly distinguishable from the known designs or the combinations of known designs. Okay. And then we are going for that one, the geographical indications of goods. Now, just see the name. What is that? The geographical indication is an indication which identify goods as agricultural goods, important one, agricultural goods, natural goods, or manufacturing goods, as originating or manufactured in a territory of the country or region or locality in that territory, where a given quality, reputation, or other characteristics of such goods is essentially attributable to its geographical origin. This is very, very, you can say that one, this is rather very restricted one. Restricted means, but it is also praiseworthy. Why? See, the geographical indication, it is with the agricultural goods, natural goods, manufactured goods, where in the territory of a country or a region or locality in that territory where a given quality, reputation, or other characteristic of such good is essentially attributable to its geographical origin. See the example of that one, you can understand. Explanation clarifies that GI, that is, that indication need not be a geographical name or like that. See, the Alfonso, that one, a locally product mango in Maharashtra. That is what is, you can even go for that one. That is the index, that is the geographical identifier, the identification. Alfonso, basmati rice. So goods includes the handicrafts goods, like you see the in goods like the in Shantiniketan, goods of Shantiniketan, or industry, also food stuff, lays, okay, that one, or rather some kind of you see Bhimnag's Sandesh, or rather you can say that one, that is Kesi Das's baked rasgulla. So you can say that one. These are the geographical naming. And India, geographical indications must be registered, and geographical indication registry examines and publishes the application before registration. See, the fight of Rasgulla with this one, that is us and Odisha. So with that one, ultimately we got that one, and registration is valid for 10 years, but it can be renewed indefinitely. And the rights, that is exclusive right to use the geographical indication on the goods, and right to obtain relief for the infringement of the geographical indication. So you can get the relief for that, and you can challenge that. So now I'm going to this one, the last speed slides, plant varieties and farmers' right, and I'm seeing that one. Uh, some of you are here, so those who might be interested with that one, see. So where the protection of plant varieties, so registration of varieties, new varieties, like you see new kind of paddy you made, so new kind of wheats you prepared, so novelty, distinctness, uniformity, the extant varieties, that is what is rather going to be diminished. So distinctiveness, uniformity, stability. So you can rather protect those things. Who can register that one? The breeders who are developers breeding that one, farmers, universities, agriculture institutes. They can do this one. And period of protection is 15 years for the annual crops and 18 years for the trees and vines. So we can even protect our mother nature by this one, that is the plant varieties. So giving them some space for living, so we can do this one. And so we can go with that one, that is we can register those varieties, that is this should be protected. And then we are having this one. So breeders right, they can produce, they can sell, they can market, they can distribute, they can export, they can import. So who are they? They are the breeders. They are rather breeding the new thing, they are developing the new thing, that is that they're developing the seeds, or rather the very life they're developing, they're breeding that one. So however, if the breeder's variety is essentially derived from a farmer's variety, so the breeder cannot give any authorization without the consent of the farmer. So very important thing to know right now, the breeder variety, if it is derived from a farmer's variety, the farmer himself develops something, and the breeder's variety, we breeded that one in the lab, or rather in some controlled environment. If that variety is rather the same thing or derived from that one, so he cannot give in the authorization without the consent of the farmer or the communities from whose varieties the protected varieties derived. So that is very important. The farmer's right is rather being protected here. And what are the rights of the farmers? The farmer's rights are to save, use, sow, resow, exchange, share, sell his farm produce, including seed, in the same manner as he was entitled earlier. Seeds for sale should not be branded. Seeds for sale should not be branded. So the farmer is having this right. To full disclosure, the expected performance of the seeds or planting materials by the plant breeder, where this failed to perform in the manner claimed by the breeder, the farmer may claim compensation from the plant breeder. Now see, if the plant breeder breeded something, but the way the breeder stated it will work, if it never yields that result, the farmer may challenge the breeder and claim compensation. Right now, I'm rather quoting something from the very new Farmers Produce Trade and Commerce Promotion and Felicitation Bill 2020, the bill which has created the chaos, the whole country, and till date we are seeing that one. Our our food producers, our that is, you can say, those who are rather giving us the food, they are rather struggling. And see the first right here given at the very top, and here the bill. They included one very term here known as trader, and they means the trader means the person who buys farmers' produce by the way of interstate trade or interstate trade or combination thereof, either for self or on behalf of one or more persons for the purpose of wholesale trade, retail, end use, value addition, processing, manufactures, export, consumptions, and for such other purposes. See the language and such other. So right now, previously, we had two groups or two different entities, two different agents. One was the farmer, second one was the breeder. Farmer himself can be the breeder. Breeder may not be the farmer, but can breed the seed and can make the seed or can generate the seed, can develop the seed. But right now, the third agent came who can challenge both the breeders, who can make breeders, who can hire breeders, who can even purchase everything from the farm. Apparently, it is not. So, from this particular line, you cannot get that one, what is actually there. But if you see this one, see the bill in chapter 2, it is stating that subject to the provision of this act, any farmer or trader or electronic trading and transaction platform shall have the freedom to carry on the interstate or interstate trade and commerce in farmers produced in a trade area. Any trader may engage in the interstate trade of the scheduled farmers produced with a farmer or another trader in a trader area, provided that no trader except the farmer producer organization or agricultural cooperative society shall trade any scheduled farmers produce unless such a trader has a permanent number account allotted under Income Tax Act. What all such things mean? Previously, the farmers were having the rights, but right now, you see, why we are rather thinking that one, that is rather nothing but the encroachment and obviously something where a right which is, or rather one act which is made to protect individuals are rather trying to protect the third party who are not in any way related with the intellectual production or intellectual creativity of the product. And the central government, if in its opinion that is necessary and expedient in the public interest so to do, prescribe a system of electronic registration for a trader, modalities or trade transaction and mode of payment of the scheduled farmers produce in a trade area. So this is what the thing. And you see in this case, the researchers are also having the right, so and that is free to complete and access the protected materials for the research use for developing new varieties of the plants. However, the authorization of the breeder is required, whose repeated use of such variety as the prenatal line is necessary for commercial production. So a researcher can grab that one, but right now no one knows what will be the fate of the researchers, as because whenever the traders will do that one or deal with that one, it is not very clear whether they will purchase only the product and whether they will go with the breeders or not also, because there can be the tie with the breeding agencies as well as the trading agencies, and ultimately the product may come to the farmer, which can help the breeders as well as those one. So obviously for the researcher might be, so we are guessing that one, some bit of problem might creep in. And next one is the role of the information professionals. So what now our perspective, what we can do? So proper understanding of Copyright Act, Information Technology Act, generalities of IPR, and rendering the support to the client on the demand of regarding such acts and rules, preserving hard and soft copies of such acts for just-in-time demand, and strictly following the directives prescribed on those acts in workplaces and daily work routines. More of this here, and here I see, if I can say you that one. So most probably, I do not know whether you can see this slide or not. Is it visible? That is my desktop, or rather the PDF.
Desktop is visible, sir.
So are you getting that one? That is the copyright guide.
We can see your PPT.
Oh, you can see my PPT. So let me stop it so that I can show you what's rather we are having that one. See, this is what is the document made by National Digital Repository, so National Digital Library of India. But here you see, this is written, that's why I cannot cite that one to you. This document is only for a draft for public consultation. We are going with that one. Please do not cite or quote without the permission of the authors. So this is what the copyright guide for Indian libraries, authors, Professor Prabuddha Ganguly, Professor Indranath Gupta, Professor Viswas H. Devaya, and Jagdish Sagar. Okay. This is should not be treated as a legal opinion. Specific situations, see this one. Professional legal advice ought to be sought. Author's opinions are personal, but this is rather one guideline, and this is the copyright. Here, the CC come. Okay. See Jagdish Sagar, Professor Prabuddha Ganguly, and Vishwas Davaiya and Indranath Gupta. Now here you see this one. That is what these are rather you can say the best representation interpretation of copyright till date given here by some of the persons who are efficient enough for this one. See the what is copyright, the concept of public domain, what are the rights of the creators and who own that one, what are the author's special right, copyright ownership, international convention, how to transfer copyright. And here comes one particular important, or rather very important thing, that is you see copyright and library operation, non-commercial public library. What actually Sudip was asking. So some of the things are rather treated here. If you click this one, you will see that one, non-commercial public library, and see digital storage for archival purposes and reproduction of the library's use of books that are not available for sale in India are two special exceptions enjoyed only by non-commercial public libraries. Okay, and you see the note here 11. And what is the non-commercial public library? Non-commercial public library includes any library that is either maintained, established, aided by the government, or notify the government as a public library, or whose primary objectives are the collection and preservation of books, periodicals, and other documents, and the provision of library services, which makes its collection accessible to the public. To elaborate the term commercial, essentially connotes activity of involved trading. Non-commercial public library would be one in that sense, that is whether or not earning profit by other means like membership fees. is a public term, public wide, whichever is not private. Okay. Electronic storage and preservation. A non-commercial public library may store a work in any medium by electronic means for the preservation if the library already possesses a non-digital copy of the work. If you have a non-digital copy of the work, you can keep that one in electronic form for preservation. This is the only one of the library exceptions applied to any kind of work, any literary, dramatic, musical, or artistic work, films, or sound recordings. The precondition is that library should possess a non-digital copy. You have to have that copy in your library. Once that is there in your library, you can make a digital copy, you can store that one, you can disseminate that one, and you can distribute that one to your users. Okay. The purpose of being preservation, the library is free to create the non-digital copy of the work from the preserved digital copy to replace the non-digital copy that has been lost or destroyed. Okay. So making a non-digital copy template for record keeping. So you can keep the template like that way. It is hereby declared that title of the work, that is the library catalog, has been maintained by the library year, and here the signature of the authorized person. Copies unavailable of books. So see, non-commercial public library person acting under his or her direction may make up to 3 copies for the use of the library. May make up to 3 copies for the use of the library of a book that is not available for sale in India. Second-hand books available from online retail or serendipitously from the second-hand bookseller should not be considered as being available for sale in India. The courts have held that items priced beyond the means of the most of the people may also be treated as not available for sale in India. So you will see this one. So here, this is what rather you can say, although it is written for the librarians, but the librarians are rather the facilitators. So I am requesting each and everyone who are listening to this, download that one by going to the National Digital Library portal and just get it printed. You will get this one. So the excellent suggestion, and at the same time you will get that one, that is the, you can say in real time whenever you are in trouble you can see that one, because you are the user and librarians are the facilitators. So if they can facilitate that one, so they can facilitate that information to you, and if you can consume that one, so that is already written over there. So obviously you can even identify which particular information is rather important for you. So now the librarians' educational exceptions are there. Now see, librarians can be involved in the exercise of educational exceptions by educational institutions, particularly Section 52 of this Act. The reproduction of any work by a teacher or a pupil in the course of instruction, one, or a part of the questions to be answered in an examination, or answers to such questions in the course of instruction has been interpreted very liberally by Delhi High Court. The Chancellor, Masters of Scholars of Oxford University, V. Ramaswamy, Photocopy Services, others. The issue of whether the prior preparation of course packs comprising different chapters from different academic works, photocopied and spiral bound for the use of students as background reading for interactive classes amounted to reproduction of a work. In the course of the instruction, the High Court, both at the trial and appellate level, answered the question affirmatively. So you can do this one. Okay. A library or other institution which is not actually conducting instructional activities would be on the safe ground in making extracts from the works in its collection for copying strictly for the purposes. So what is that? This is rather, you can see, a good guide for you, that you can just go through this one. And in case of, and you see the glossary is also there. And here you see one very yes, you see this one, what I was talking about. This is what the fair use. See, fair use and fair dealing, these terms are often used interchangeably, though they do not mean quite the same thing. Fair use is a broad US term covering all exceptions in general terms, depending on nature, extent, purpose, and commercial effect of any use of copyrighted work on the facts of the case. Fair dealing in India and other common law jurisdictions generally is a precondition for the exercise of the exceptions of personal use, research, criticism, and the news reporting, meaning reasonable use of the work according to the actual environment. Reasonable use of the actual work or work, the term also sometimes used loosely for all copyrighted exceptions enumerated in the statute, loosely. So this is what is the perspective of fair use and fair dealings. So if you go through this book, this is not a this is a pamphlet, you can say. It is lesser than 39 of that is 39 pages. So I am requesting all of you, you can make this one a copy with you and go through this one for 2 or 3 times. You will understand most of the intricacies involved therein regarding the copyright, regarding the documents you use, regarding the uh, intellectual underpinning involved therein, or creativity underpinned with that Copyright Act as well as the IPR Act. So that is what is the deliberation. So right now, last and but not least, let me say that one. Uh, Although I told you that one, this particular lecture should be of very not lengthy lecture, but however, this is rather the problem of the teachers, as once they start talking, they merely think that one, whether someone is listening or
But
not.
we enjoyed it thoroughly, sir.
So whether they are listening or not. So with this one, I am rather concluding. So right now, from my part, it's over. Have a nice evening. And if you have something, so first of all, my
তারা
suggestion.
অ্যানালগ বা ডিজিটাল বর্ণনা দেওয়া যাবে।
Which one?
2 নম্বর হচ্ছে ডেটা সুপাঠ্য বা সহজবোধ্য ভাবে নতুন ভাবে উদ্ভূত ডেটাবেস গঠনে গ্রহণযোগ্য। আর
Hello.
3 নম্বর হচ্ছে অনলাইন লাইব্রেরি ক্যাটালগিং এর বিদ্যমান নথির সঙ্গে সামঞ্জস্যপূর্ণ।
Hello.
অনলাইন হ্যাঁ,
চন্দন, হ্যাঁ বলুন,
Chon-
হ্যাঁ বলুন।
চন্দন, আপনার কি কোনো কোশ্চেন আছে? Hello. Anyone have any doubt or question you want to ask to sir?
Okay.
Anyone? Okay.
Okay,
Yes, sir.
fine.
Yes, say so. Yeah.
So, okay, fine. So I understood that one. People understood that one clearly. People understood that one meticulously, or people understood that one in better way, so that they understood that one because uh, the ready reckoner is already available. And the thing is that one aspect is the copyright, another aspect is the patent. For academicians, practically speaking, these two things are important. But once you will go to your profession, then you will be encountering with that one, that is the trademarks and other things. But IPR itself is rather having its periphery so bigger, it's a fat periphery. So that's why at a single go, if you talk, but if this was rather one physical class or rather a kind of workshop like that one, so in that time you would have the facility to communicate one-to-one situation, or rather many to one, or rather you can even see your peers also. Right now you can't even see your peers, and that is what you are not being sure whether others understood or not, or rather that you are the only fellow you understood or half-baked one. So with this one, so I think I tender my sincere thanks to Vivekananda Centenary College for inviting me for delivering one lecture on that one. So for IPR as well as for our people, we are here for doing some kind of social good for our new breed of inventors and the developers, and those who are rather having a very cognitive mind, rational with them, and those who can do the proper justice with the education, and ultimately they will get rid of all the evils that are there in the society, and they can be a real human being, what Swami Vivekananda and Paramahamsadev stated. Thank you very much. Thank you.
Thanks a lot, sir. Thanks a lot. On behalf of our college, Ramakrishna Mission Vivekananda Centenary College, I like to say that we are enlightened through your this talk, and we get to know many aspects of IPR which is not known to us. So rather, maybe in future we'll explore that. And we thanks a lot, sir, to giving time and that enlightened us. Thanks a lot.
Okay, thank you. So can I quit, Ravi?
Uh,
Is it the time for quitting, or rather you have something?
Nothing else there.
Okay, then fine. It's okay. So fine. Thank you very much.
Thank you, sir. Thank you. And thanks to all the participants. Thanks.
Yes.